Okay, let's unpack this. You've brought us a really fascinating sort of real-time legal drama.
Yeah, that's right. It's Ricky Lee Pinson versus the Secretary of the State of California et al.
And it seems to put a real spotlight on, well, procedural stuff, right?
Yeah.
But also the power an individual can have.
Exactly. Our mission here is to kind of dig into the sources, pull out what's critical from this high-stakes exchange.
And figure out not just what happened, but why it actually matters for, the legal system's integrity.
Absolutely. What's so interesting is the petitioner, Ricky Lee Pinson. He's a disabled litigant acting for himself, per, they call it.
Right, per.
And he's taken these incredibly precise strategic steps against the opposing lawyers, Kajar, McKenna, and Sockhelper.
So it's not just some minor argument.
Oh, no. This is like legal chess. It's really something.
Okay, so what's the core issue here? You mentioned a contradiction.
Yes. This is where it gets really interesting. Back on June 24, 2023, KMS filed an answer. That's their formal response,
right.
And in it, they explicitly said their representation was, quote, for itself and no other defendants. Pretty clear.
Okay, only for themselves. Makes sense.
But then, you fast forward to July 8, 2025, and KMS files a demurrer.
A demurrer, that's like a challenge to the lawsuit itself, saying it's flawed.
Exactly. But this time, they filed it on behalf of Defendant George S. Bernal.
Wait, the same Bernal they previously said they didn't represent?
The very same one. It's an astonishing flip-flop, as you said.
I mean, how do you even justify that legally? It seems like a huge problem.
It's an incredibly difficult spot for KMS. It directly contradicts what they already told the court.
So did Mr. Pinson notice this right away?
Oh, immediately.
Yeah.
He confronted them informally first, sent a meet and confer email, June 27, 2025.
Okay, trying to resolve it without court action.
Right. But even then, like on July 1st, KMS basically doubled down, said they saw, quote, no reason to correct the record or withdraw.
Wow. So they just refused.
They refused. And that really set the stage for what Mr. Pinson did next.
Which was, you have this per litigant disabled up against a law firm.
He executed this incredibly meticulous plan, August 5th, 2025, 8:00 a.m. sharp. He emails KMS, warns them he's about to file.
Gives them a heads up.
Just 4 minutes later, 8:04 a.m., boom. Electronically files his ex parte application to disqualify counsel.
Ex parte, that's like an urgent, immediate request, right? Limited notice.
Precisely. For immediate action like this. Then, 8:07 a.m., he files a separate declaration supporting it.
Okay.
And by 8:31 a.m., proof of electronic service is filed. Done. Super precise.
That is incredible speed and strategy, especially for someone representing themselves.
Absolutely. It shows a really sophisticated grasp of procedure. You don't often see that.
So what's the legal basis he's using? What's he arguing in this application?
He hits them on several points. First, unauthorized representation. He points to the rules, civil procedure sections 284, 285.
Rules about how lawyers have to formally say who they represent?
Exactly. And he highlights they never file the mandatory court form, the MC-050. That's the official substitution of attorney form.
Ah, the specific form is missing. Okay.
Then, second, he argues judicial estoppel. The idea you can't tell the court one thing and then take the opposite stance later.
Right. The flip-flop argument.
Precisely. And third, critically, he talks about the prejudice this causes him, especially as a disabled litigant, affects his access to justice under the ADA and state law.
That adds another layer.
It does. And he's not just making general arguments. He cites recent cases, like Agnon v. Agnon, City of Los Angeles v. PricewaterhouseCoopers. Shows he's ready to argue for bigger sanctions, too, for wasting court time and misconduct.
Wow. He's really built a comprehensive case here.
Totally. It's a full-on assault on procedural grounds.
So the application's filed, the pressure's on KMS. What exactly is Mr. Pinson demanding they do now?
He wants immediate compliance, file that MC-050 form properly, withdraw the filings they made for Bernal without authorization.
Makes sense.
And also respond to discovery requests he's apparently had pending for a while.
Ah, so there's other stuff lingering too. And if KMS doesn't comply, what are the stakes here? It's not just getting a form filed, is it?
Oh no, far from it. The consequences could be really severe. He's asking the court to disqualify KMS entirely from the case.
Kick him off.
Yep. Strike all the unauthorized filings they made for Bernal. Potentially enter a default against Bernal himself.
Meaning Bernal could lose without even fighting the case further?
Could happen. Plus, deeming discovery matters, admitted basically saying KMS can't dispute certain facts anymore because they didn't answer, and financial sanctions, of course.
Okay, this is serious.
And there's more. He's even threatening to use this to bolster a separate motion he has pending for judicial reassignment, implying, maybe the whole case needs a fresh look from a different judge.
So this goes way beyond just a technical error. It's about fairness, proper representation.
Exactly. It's about upholding the fundamental rules that make sure the system works fairly for everyone involved.
So wrapping this up, this deep dive, it really shows how understanding the nitty-gritty, the procedures, can be incredibly powerful, doesn't it?
It really does. Even when you're facing big challenges, knowing the rules can level the playing field.
It's a vivid reminder. These seemingly small rules, these technicalities, they exist for a really important reason.
Absolutely. To ensure justice is accessible and fair.
Which kind of leaves you wondering, doesn't it? In these really complex legal systems we have, how much does sticking to those basic procedural rules really matter for keeping public trust?
That's a great question, especially for ensuring fair access. For people who might be vulnerable or at a disadvantage in the system, it's something to think about.